All right, welcome everybody. I'm Amy O'Hara. I am the president of APDU, the Association of Public Data Users, and I want to welcome you to Demystifying Data Privacy, Part 2. If you haven't seen Part 1, go look for it, where we are going to walk through our new primer on the Privacy Act of 1974. First, a bit of housekeeping for this webinar. If you have a question, please drop it in the chat and we will try to get to it during the presentation or when we get to Q&A or even afterwards. And if you are unable to get your question through the session, you can also send us an email at info@apdu.org. So some of you may have missed the first webinar in the series, so I'm going to provide a bit of introduction and also encourage you to go watch the recording of that event, and we're going to put the link in the chat. So you may have heard that people are concerned about data privacy, and there's recent polling from the Center for Democracy and Technology that suggests that concerns about data privacy are widespread and bipartisan. More than 80% of people across the US say that having legal protections for the sensitive information that government agencies have about them is really important, but less than half of them know their legal rights. And it's not just the general public that has these knowledge gaps. As we've embarked on this work through APDU, it has become apparent that there are so many information silos. Data users only talk to data users and technologists talk to other tech people. And in addition to these information silos, we found that there was a lot of not quite accurate information out there. So with support from the Annie E. Casey Foundation, we brought together a team of experts to help fill those gaps and raise awareness to these issues so that we can all work more effectively together to strengthen data privacy protections. So today we are talking specifically about the primer on the Privacy Act of 1974. And I am so pleased to introduce our special guest stars today. We've got Maya Bernstein, who served as the Senior Advisor for Privacy Policy in the Office of the Secretary of HHS for over 20 years until April of 2025. She helped develop and implement HIPAA, worked in privacy at IRS and HHS, and she was awarded the Federal Privacy Council's 2021 Award for Excellence. And I'm also delighted to introduce Bethanne Barnes, who served as the Acting Chief Data Officer for the Administration for Children and Families, ACF, starting in 2019. And in her work there and in her prior role when she was at the White House as the Special Advisor for Evidence-Based Policymaking at OMB, she played a leadership role in advancing the responsible use of data. And this is consistent with privacy protection so that we can improve our federal programs. So when these two people talk about the federal data privacy landscape, it's because they know it. And we are so lucky that they're willing to share their time and knowledge with all of us. And I'm going to hand it over to them. Thank you for joining us today.
Aha, now I can actually advance the slide. Sorry about that. Hello, everyone. I'm Maya Bernstein. Thank you so much for that introduction. It's delightful to be here with you, Amy, and with my consulting partner, Bethanne. We're going to talk to you today about the Privacy Act and the primer that we worked on together under the auspices of APDU. And here's just a little quick agenda about what we're going to go through. We're going to talk a little bit about the history of the Privacy Act, its structure, its scope, the definitions that help you understand what's covered and what's not. Talk about the obligations of federal agencies and what rights individuals, what you have under the Privacy Act, and then talk a little bit about penalties and redress. And then we'll go to your questions. There might be other topics come up if we have time, but I think we should just get started. So how did we get to the Privacy Act of 1974? You know, in the 1960s and early 70s, there was the shift from paper files to more automation. And at that time, the federal government really was the only entity that had both the resources and the technology to have these huge databases. Now we're seeing them, of course, in the private sector, which rivals the federal government. But at that time, people were very concerned about what the federal government could do. And Congress was particularly concerned that the new technology made it too easy for agencies to cross-reference personal data, to create some kind of standard universal identifier, maybe like the Social Security number, that can link every detail of a person's life, you know, across multiple agencies and over time. So their goal was to prevent the creation of some kind of massive centralized federal database that could easily be tracked to every individual. And what they did was Congress tasked the then Secretary of Health, Education, and Welfare to convene an advisory committee about this, to give advice about this situation. It was called the Advisory Committee on Automated Personal Data Systems, and it came out with this report, the cover of which you see here. That came up with its central recommendation was something called a Code of Fair Information Practice, and that code is reproduced here. It had sort of 5 parts, although there have been many other formulations over time. Different organizations have formulated it differently, have broken up these into more granular pieces. And sometimes they're called FIPS, Fair Information Privacy Practices, or Privacy Principles, something like that. One particular concern of theirs was about individual control. So before the Privacy Act, and before these recommendations, citizens often had no way of knowing what the government held about them. And they couldn't figure out how it was used, or how to get access, or how to fix errors. And so Congress was also concerned that inaccurate or outdated information in government files could be used to unfairly make decisions about them. So their goal for fair information practices was to allow people to see their own records, allow people to request amendments for inaccurate or untimely or incomplete information, that sort of thing, like information that was not good quality for making decisions about people, and to stop information for being used for a different purpose than it was originally collected. So, as I said, these have been reformulated many, many times. And then what we had, if you recognize the Watergate building here, during the Watergate scandal, where people were concerned about excesses of the government at the time, surveillance against political enemies, that sort of thing, there was this rising distrust of government. And that was really the catalyst for getting the legislation to be passed. In this environment of distrust of government, rapid advancement of technology, it was easier to get something passed, even though it had been brewing for quite a while with multiple different kinds of proposals at the time. None of them could really get through until Watergate came along. At the time, then, the Congress was particularly concerned about unchecked power of the federal agencies to collect and store and make decisions of how people, or to surveil people in ways that they found to be inappropriate. So they wanted to sort of curb this big brotherish kind of surveillance. And, there had been this intense scrutiny and anxiety, I guess you'd say, about, various kinds of misuse or illegal collection. The idea of the goals then were to prevent the government from having record-keeping systems, the very existence of which was secret, from secretly monitoring people or maintaining dossiers about them and so forth. And again, to make these massive databases that could be kept by the federal government, but not really by anyone else. Let's see. Then just an overview of the structure of the Privacy Act. It imposes obligations on federal agencies and also their contractors. If an agency contracts out to do work that covers Privacy Act records, it grants certain rights to individuals about whose records are maintained. And it incorporates in different parts of the law this code of fair information practice that you saw earlier. And then there are both civil and criminal penalties, although, as we'll see, the criminal penalties, there's not a lot of oomph in the penalties, for better or worse, and we'll talk about that. Now I want to turn it over to Bethanne, and she's going to talk about how things really work here.
Well, so as Maya so beautifully laid out the motivations behind the Privacy Act and where the Congress was trying to go, we're now, before we can transition into what those obligations are and all of those things, we need to define some key terms. And consistent with our commitment to be very transparent and highlight the negative space as we're moving through this, we're going to highlight what the definition of a thing is, and then also highlight what it isn't, right? Like, if this means this, then it means this is not covered. Okay. Starting off, the definition of an agency. The Privacy Act applies to agencies, And the definition of an agency tells us who must comply with the Privacy Act's requirements. Within the statute, an agency is an entity in the federal executive branch that is a cabinet level or other non-cabinet agency, but it is the highest level of that entity, right? So think like the Department of Homeland Security or the Equal Employment Opportunity Commission. And as a part of that, it also includes things like independent commissions and the US Postal Service, right? What that does not include are things that are not a federal executive branch agency. So surprisingly, that also includes components of the executive branch that have been defined as not an agency. For example, components of the executive office of the president, whose only job is to advise and assist the president. And that includes folks like the White House Counsel or the National Security Council or some of the other policy councils. That also excludes folks over in Congress, different branch of government. Other parts of Congress include GAO and the Congressional Budget Office. It also excludes anyone in the federal court system, as well as state, local, tribal, or territorial governments, including all of the branches of government within those entities. So those folks are not covered. Okay, moving on to an individual. So the definition of an individual is important because that determines who gets rights under the Privacy Act. And under the statute, an individual is a natural, real person who is alive and is a US citizen or legal permanent resident, which we sometimes refer to as being green card holders.
Yeah, for the lawyers out there, not a corporate person, an actual person.
So yeah, so what that means of who is not covered are an organization or a corporation, right? Because that definition of personhood doesn't extend here. You lose the Privacy Act rights when you die, so it doesn't cover dead people. And it also does not cover non-US people. So anyone who's in the country, who's not a citizen or a legal permanent resident, who has any other kind of immigration status is not covered. Note that the APDU also released a 2-page brief on mixed systems, which are systems of records that contain information on both individuals and non-individuals, like people who don't meet the categorization of individual for a variety of reasons, including how the Department of Homeland Security pioneered an approach to administratively grant non-US persons, right, folks who don't qualify as an individual, administrative Privacy Act rights. Okay, moving on. Next key definition is a record. The definition of record is important because it defines which information could potentially be covered by Privacy Act protections. First, a record has to be information that is actually about an individual. For example, if the record is about a company and the person's name that filed the form on behalf of the company is in the record, then that record is not about the person that filed the form. So it wouldn't necessarily be a record. Similarly, for federal employees, if you're including your name in your work your name on your work product and submitting that as a part of your job, those are not considered records because the record is not about you. A record also has to be connected to a personal identifier, which is kind of a tricky term. The term personally identifiable information, or PII, is not in the Privacy Act. That concept came later. That was not something that was envisioned here. So that makes us think, what's an identifier in this context? Well, an identifier can be almost anything, so long as it directly identifies the individual. Now, identifiers don't have to be unique, right? Like the example that we give in the primer is that a person named Rosalie her name, Rosa Lee, is an okay, like that counts as an identifier, even though there may be multiple Rosa Lees in the world. But it doesn't just have to be a name. It could also be an account number, a fingerprint, a photo of Rosa Lee's face, or even a photo of her unusual tattoo. It's also important to note that for the Privacy Act, those identifiers have to be a direct identifier. So in other words, you can't put together separate fields that are like a birth date, gender, and a zip code, and have that qualify as being a Privacy Act identifier, even if collectively those fields actually identify a person. Okay.
Can I add one thing?
Sure.
Which is what's one of the amazing things to me in this section about the Privacy Act is that it actually anticipated facial recognition. It says in the law a voice print or a photograph could be an identifier, meaning it contemplated you could, pluck out one of those from a list, and as we'll see in the next slide. And that's kind of unfathomable to me. 50 years ago, this technology didn't even really exist, although now it certainly does and is very much in use.
Yeah. And so in addition to being information about a person, about an individual that meets the definition of the individual and containing a personal identifier, that record also has to be maintained by a federal agency in order to be a record. So that means that things that don't qualify as a record or anything that fails any one of those prior tests we talked about, right? Like if it's not maintained by an agency, then it's not a record. If it's not about an individual, it's not a record. And if it doesn't have a direct personal identifier, then it's not a record. A concrete example of not a record that might be familiar to this audience are those restricted access files that agencies create, which may contain fields for date of birth, birth date, gender, zip code, and a whole host of other very personal information, but which are only identified by a randomly assigned number within that system. And that means that it's not a record, even if you could re-identify the person fairly easily.
There's a question in the chat about whether contractors count if they're managing records at the behest of a federal agency.
So I'm curious if you want to talk about contractor coverage at this point in time, or if you want to do that later. Contractors they do count, like the requirements of the Privacy Act do apply for federal contractors that are setting up, maintaining, and operating a system of records on behalf of a federal agency.
Exactly.
And there are terms in the FAR that there are specific clauses that are required to be incorporated into those contracts to make sure that those things trickle down. And that's all cited in the primer. So you can get the specific language and requirement. Okay, so moving on. So we have figured out who must comply with the Privacy Act, who is covered by the Privacy Act, and what kinds of information could potentially be covered by the Privacy Act. Now we get to the crucial definition of a system of records, which defines what information is actually covered by the Privacy Act. So in order to be covered, the record has to be in a system of records, which is a collection of records that we just went through, where the record is retrieved by the personal identifier, right? Okay, so that means you have to run the gauntlet of meeting every single definition that came before, and then you've got this collection of records that we know are records, and we have to figure out if we are actually using that unique direct identifier that is in the record to pull up the record in our normal agency workflow. And it has to be a part of the agency workflow. They need to call it up by that name or ID number or whatever. It's not enough for that direct identifier to be present in the record. And it is, even if it would potentially be possible to call up and retrieve the record by that direct personal identifier. The presence and ability to do those things are irrelevant. It has to be a part of the regular agency workflow that the agency actually retrieve by the personal identifier in order for it to count as a system of records. It's also important to know that a system of records definition has zero relationship with where those records live. They could be in one, multiple, or zero IT systems. They could live within a single agency or multiple agencies. And an IT system could have one, multiple, or zero system of records in it. Like those have no relationship to each other. So let's talk quickly about some kinds of examples of the things that don't qualify as a system of records. For example, if an agency has, let's say, a database full of records, but it only ever pulls up the information that they're going to use, for example, by listing everybody that's in a certain zip code, then that's not a system of records, even if that list contains all of the identifying information on it, right? The source system would not be a system of records. It could be even finer, that you could be pulling up everyone that was in a zip code on a certain date. But if you're still not pulling them up by personal identifier, it's not a system of records. And that can go on ad nauseum. And again, we just really want to emphasize that system of records are not the same thing as IT systems. They're not, you have to meet, they're different concepts entirely. Okay. And moving on. So those are the key definitions. Moving on, a summary of one of the biggest stewardship obligations that the Privacy Act imposed. This is a summary of the biggest responsibilities that the Privacy Act imposes on agencies. Agencies are required to only collect the minimum amount of information that is both relevant and necessary to carry out a purpose required by a statute or an executive order. Agencies must also collect data directly from the individual to the greatest extent practicable. And that's important both because people are the experts on themselves, so data may be more accurate, and it also increases transparency. You generally know if you're giving your data directly to a federal agency. You may be less clear if you're giving data to a state, local nonprofit, or a private company. Agencies are also required to get consent from folks before disclosing their data, with a big asterisk. Maya's going to talk more about that in a minute. And before using a record to make a decision about someone or sharing the record externally outside of the agency, agencies must make a reasonable effort to assure that the record is accurate, relevant, timely, and complete. Agencies are also responsible for setting up and enforcing the rules of conduct and the associated training for everyone involved in designing, developing, or operating a system of records. And similarly, agencies must set up the administrative, technical, and physical protections to keep records confidential and safe from threats that could cause substantial harm, embarrassment, inconvenience, or general unfairness to individuals. There were also amendments to the Privacy Act from 1988 that established requirements for agencies to establish computer matching agreements in certain circumstances. And finally, agencies need to keep logs or an accounting of disclosures, which Maya is going to talk more about in a minute. The Privacy Act also requires agencies to provide us with two kinds of notice about the data they're collecting about us and how they're using the data. First, they have to give you an individual notice at the time that they are collecting the information from you. That's all of the fine print labeled in the Privacy Act statement on federal forms, like your IRS forms and things like that. And that should include information on the authority for collection and how the agency is using and disclosing the information and some other stuff. Second, the agency also has to provide a general notice, sometimes called a constructive notice. And this happens via a Systems of Records notice published in the Federal Register. Very exciting. Among other things, this notice is required because the government is not allowed to operate secret systems, right? Like as Maya said before. They have to tell the public what they're doing. Now, these SORNs are incredibly important because they're a combination of, honestly, I think of them as the most ineffective press release ever created. And also, they are how the agency writes the rule book that they are then required to follow for the data or for the records. And APDU has a how-to guide to help you decipher and analyze these SORNs. Note that the SORN can change the rules about how your data is used and shared after they have collected the data from you. Okay. Couple of other quick things here. Agencies must try to notify you if their records are made a part, if your records are made a part of a compulsory process. Let's think like a court order or a subpoena. They don't have to succeed, but they have to try. Agencies must also allow individuals to see records about themselves or get copies of those records. And agencies must also allow individuals to request amendments, like corrections to records that are not accurate, relevant, timely, or complete. And then agencies must in turn publish the exact steps that an individual must follow to exercise these rights in that SORN in the Federal Register. So you know how to do it. Okay, moving on to the rights of individuals. So the rights of individuals are generally the mirror of those agency obligations, right? So some of the big ones folks think about are getting those notices that the agency is required to provide, right? Like those are kind of the flips. Although this requirement and a few others, the agency may be exempt from. Maya's going to go into that in just a minute. Individuals also have the right to see or get a copy of the records about themselves, and they've got a right for those records to be accurate, relevant, timely, and complete before the agency uses it to make a decision or shares that record with another agency or entity, which is part of the reason why individuals have the right to request for those records to be amended. Now, just because you request an amendment doesn't mean that the agency is actually going to make that amendment. There's a whole process for you to go through and appeal if they don't grant the request the first time around. There's a whole process, and there are some provisions for making updates. If they then decide to make the change, they'll follow that through wherever the record has gone. And if they don't make the change, you have the right to attach your own statement about why you think it was wrong. And finally, individuals have the right to sue to get redress, including getting the agency to give you access to the record or amend the record or all of those things if they don't do it in the first place. Or if they violate their obligations, you can also seek financial penalties and to be made whole, although it's very difficult to bring a case. Maya's going to talk more about that in just a minute, but now I'm going to hand it over to her to talk about the accounting of disclosures.
Okay, there we go. So an accounting of disclosures is one of the things you have a right to obtain from an agency. An agency is obligated to keep a list of the disclosures they make of your records with a couple of small exceptions. They don't have to keep records when they disclose inside the agency, and they don't have to keep a record if they disclose under the Freedom of Information Act. But otherwise, they have to keep a record of to whom they gave your record in every case. And so that record has to have the date, the nature, the purpose of the disclosure, the name of the address, and the address of the person to whom the disclosure is made. And you may hear in other privacy laws, or people, if you deal particularly with the HIPAA privacy rule, that covered entities who have to comply with these privacy laws really complain about this provision. They think it's very burdensome and that nobody ever asks for this accounting of disclosures, so why should we bother to keep it? However, in my view, this is one of the most important rights that we have in the Privacy Act, and that's because the time that you really need an accounting of disclosures is when something goes wrong. So if an agency has an error in your record and has been propagating that record around, that's bad. How do you track down to whom got that wrong record so that you can correct it? You're going to use the accounting of disclosures. Indeed, when you seek an amendment of your record, if the agency agrees to your amendment, they are then required to use this accounting of disclosures to send everyone who previously got the record the updated record, and from then on to send the proper record. And if they disagree with your amendment and they don't make your change, there's still you can ask to put a note of disagreement in the record, a brief note, and that has to accompany the record from then on. But also, the agency is required to again use this accounting of disclosures to send that statement every time it sends the record, but also to everyone who previously got it. So this is a way for you to fix problems when they arise. And thankfully, it does not arise very often. People don't ask for it very often, and that's the way we want it because we don't want things to go wrong very often. So even though it may seem like a burden, and I will say an agency doesn't have to keep a contemporaneous record every time they disclose, but they do have to be able to recreate it at the time someone makes a request, right? Okay, let's see. So I'm going to talk a little bit about the First Amendment because that's a hot topic right now. It turns out that the Privacy Act has a special prohibition for an agency collecting information about how people exercise their First Amendment rights. And the courts have said, although it's not in the original statute, cases have said that this provision applies to all information, even if it's not contained in a system of records. And that's like the one place where it doesn't matter if it's really retrieved by identifier or not, as Bethanne explained. It doesn't matter. Even if it's not contained in a system of records, an agency cannot collect information about how you exercise your First Amendment rights. And this is designed to prevent, keeping dossiers on people who express views or practice their religion or assemble secret S, all the normal, First Amendment rights that we hold dear. And as you might imagine, given the origins of the Privacy Act, as I mentioned, with Watergate and other excesses of the government in our history, we know that the FBI kept records on Martin Luther King, on people like John Lennon, on protesters in the Vietnam era, even more recently on Black Lives Matter protesters and so forth. The government has to be very careful because there are rights that individuals have if they should collect information about your First Amendment rights. So for example, some of you may be familiar with when you fill out the census form, it says under ethnicity, please do not fill in your religion here. And that's because someone like me, whose family is Jewish, might be tempted, given that Judaism is is it a nation? Is it an ethnicity? Is it it's sort of all these things. People are tempted often to put their religion into that space, and the law prohibits the Census Bureau from collecting your religion because it's how you exercise your First Amendment rights. People do it all the time anyway, but that's why that notice is there in the census forms if you happen to have seen that. When can the government, of course, there are exceptions to all these rules, when can the government actually collect information about how you exercise your First Amendment rights? Well, if a statute particularly says so. And so, for example, in EEO rules where you're being discriminated against because of religion, then we have to collect information about your religion in order to, or figure out if you've been discriminated against. If you particularly authorize it, if you give your prior consent and say it's okay if you collect these records about me, then the government can do that. And then there's this, pertinent to and within the scope of an authorized law enforcement activity. And that definition is subject to a lot of discussion in the courts and, in cases right now about what really does it mean to be an authorized law enforcement activity, under what circumstances can I collect this information. Some courts, for example, have held, well, it has to be an ongoing activity, and once the activity is over, you have to get rid of the records. Or if the litigation or investigation closes, you have to destroy those records. So this is an important right, and it's interesting to me that it's not connected to the system of records business that everything else in the statute is connected to. Okay, so I will say that people often think of the Privacy Act as an access and disclosure statute. And as Bethanne eloquently described, there are all these other rights in the Privacy Act that have nothing to do with access or disclosure. You have the right to get notice. You have the right for good quality information. It has to be accurate, relevant. None of those things have to do with whether you get access or not. However, one important piece of the Privacy Act is how an agency is able to disclose your records without your consent. First of all, the basic rule is get your consent, right? Section B of the Privacy Act says you shall not disclose these records without the individual's prior written consent. And then there's the unless. And then there's 13 exceptions. And most privacy laws are structured like this. No disclosure, but here's the exceptions. And I listed them all here on the slides, but I'm only going to talk about the ones that are particularly important or maybe particularly relevant or arise most often because we won't get through them all. First of all, I sort of alluded to earlier that the Congress did not want to sort of bollocks up the regular course of agency business. So it allows agencies to disclose within an agency, meaning the entire agency, a whole department. Bethanne and I met at HHS, at Health and Human Services. It's a big, complicated department. We're running an insurance company in Baltimore. We're regulating drugs. We're running public health in Atlanta. There's a research hospital in Bethesda. Like, it has many, many different missions. But within that entire department, one agency can disclose to another if that other agency has a legitimate need to know the information for their work, even if it's not related to the original purpose for collection. Okay. The second exception is a little bit complicated, so I'll take a minute. B2 says, if the Freedom of Information Act requires you to make a disclosure, then the Privacy Act is not going to prohibit you from doing that. Okay, so when does the FOIA require you to make a disclosure? And over time, the courts have developed a balancing test. It's the public interest versus the privacy interest of the individual. If the public interest in knowing the information and shedding light on the workings of government outweighs the individual privacy interest, then you must disclose under the Freedom of Information Act. But if there's no public interest and even the tiniest bit of privacy interest, then the Privacy Act prohibits you from disclosing. So normally the Freedom of Information Act has the presumption of disclosure. You must disclose the information, and it has some exemptions. You're allowed to withhold for these following reasons. Sort of a similar structure as this part of the Privacy Act, and it's a little complicated because people get them confused. An agency has discretion to disclose information under the Freedom of Information Act, even if it's permitted to withhold it. However, the Privacy Act removes that discretion. So either you are required to disclose it under the Freedom of Information Act because the public interest outweighs the privacy interest, or you are required to withhold it under the Privacy Act because the privacy interest is stronger. That's a little bit complicated, but that's the brief version of how that works and how those two statutes work together. B3, a routine use, we're going to teach an entire class just on this section because it's the most, misunderstood maybe, and maybe misused piece of the Privacy Act. The way I think of it is kind of an escape valve. Congress put in all these exceptions to the disclosure prohibition rule, ones that it could contemplate at the time 50 years ago that an agency might need, but it couldn't anticipate everything. So what it gave us was an ability to add a new disclosure by following an administrative procedure. Unfortunately, it called it a routine use, which is silly. A routine use is neither routine nor really a use of information, by which you might think a use inside an entity. It makes people confuse it with the B1 need to know thing, and we have a little table about that in the primer. Or maybe we have it in the routine use one, I can't remember, but they're not the same thing. A routine use is a disclosure outside of the agency for a purpose that is compatible with the reason for which the agency collected the information in the first place. Also, unfortunately, the word compatible is never defined. which allows us to teach an entire hour class about it. But the important thing to know, it's a disclosure outside of the agency. It doesn't duplicate any of the other disclosure provisions that are already in the statute. It has to have this compatibility thing, which means either it's related or there's a really good reason, like you have to disclose it because you found fraud in your program and you're going to disclose it to the entity that's going to ferret out the fraud, or because Congress told you in some statute you have to disclose even if it's completely unrelated. The procedure is that you publish a notice in the Federal Register, you collect comment for 30 days, and 30 days later, then you can use that new disclosure. That's, I think, what I'm going to say about that for the moment. Let's see, did I miss one that I wanted to talk about? People who are interested in census, it's agencies can get access to census. If the census asks you for information or you need to disclose the census, it's not meant to interfere with census activities. There is a provision for statistical research or reporting, but this one is rarely used because the Privacy Act requires that this disclosure be made without identifiers, and you have to give advance written assurance that it's used only for statistical purposes. And if you disclose without identifiers, it means you can't link up the data with something else. So people use other provisions to try to move data around that they're going to use for that purpose. B7 is in the news lately. B7 is when a law enforcement agency has an investigation ongoing and it needs information that it thinks you have at your agency, it can make a request for the particular information that it needs. And that this provision permits an agency to disclose in response to such a request. Let's see. And then I think the other one that's worth talking about, yes, you can disclose to the Congress and to its various agencies, but pursuant to a court order. Essentially, this has to be a court order by a federal judge. It's not a clerk issued. It's not a subpoena signed by a U.S. attorney. It has to be a federal court, not a non-federal court of any kind. And I have this note here that said it's not discretionary. So there are two of these disclosure exceptions that you can think of as not discretionary. It's important to know all of these are discretionary except two, meaning you don't have to make these disclosures just because the statute permits it. Going back for a sec, you have a request from law enforcement doesn't mean you must respond. You may respond with a negotiation between the two agencies about what they really need and how much they really need and so forth. This may get elevated to the agency heads to work out, but an agency need not respond to a request like this or make any of these disclosures just because the statute says it's permissible, with the exception of two. Here we are, where the FOIA requires it. I go back for a sec because the law requires it. The law requires it, the law requires it. And over here in B12, if a court orders you to do something, well, you can try not to respond, but at some point you're going to get thrown in jail. You're going to be held in contempt. So you can't really think of a court order normally as discretionary. You have to respond to those. Okay. I want to talk about criminal penalties real quick. There are criminal penalties in the Privacy Act, but they're not very strong. In order to be accused, well, in order to have charges brought against you or to have them proved, the Department of Justice would bring the case and they have to show that there's willful intentional misconduct, meaning you knew it was wrong to make the disclosure and you did it anyway. Or you knew you had a system of records under the law and you maintained it and used it anyway, even though you knew, without the system of records notice that needs to go in the Federal Register. And also there's one provision that applies to anyone in the world. If you try to obtain records that you know are covered by the Act by some kind of false pretenses, by fraud, by impersonating someone's identity, something like that, you also can be charged with criminal penalties. But it's a misdemeanor, it's less than a year, and a $5,000 fine. And generally, those are not big enough crimes for the Department of Justice to bring a case. It's not worth their time. And so in 30 years of working on the Privacy Act, I'm not aware of any case that's been brought by justice under the Privacy Act for criminal penalties. Usually when something goes wrong like this, they find another statute that has better penalties. Theft of government property, for example, or something like that. Okay, And then I think there's one more, or one or two more to talk about redress. Bethanne mentioned that there are civil remedies you can sue, but it's difficult. So if an agency denies your request for access or your amendment request or an accounting for disclosures, you can sue them. If they fail to maintain your records that are high quality in the way that we described, and they make a decision about you that's not fair or that harms you, or they fail to comply with anything else that has some adverse effect on you, you can bring a lawsuit. But you have to prove, it's very difficult to prove. You have to show that there was wrongdoing. You have to show it was willful and intentional. You have to show there's a nexus between the harm that you experienced and the wrongdoing. And you have to show actual out-of-pocket damages, not pain and suffering, you have to show that you spent money as a result. But even if you can show just 1 penny, then the minimum penalty is $1,000. So if you can show all those things, you can get, for each instance, you can get a recovery, but it is very hard to bring such a case. In the cases where people have succeeded, the agency probably really went astray. And so they should be getting sued for that kind of thing. But it's, as I say, very, very difficult. And it's one of the failings, I think, or at least one of the limitations or gaps in the law that people are now trying to address with various kinds of legislation. Okay. I mentioned what you can, there's one other thing I wanted to mention, which is there are very limited cases where you can get injunctive relief. Injunctive relief means you can make somebody do something or refrain from doing something. And the court can only do that in the case of giving you your record, if you had an access request that they failed to comply with, or they can make them amend the record, either in the way you requested or the way the court sees fit. But otherwise, for example, if an agency is disclosing wrong information about you, or an agency is running a system of records without a notice, there is no way to say you must do that. You have to sue them in the way that I said. You have to show out-of-pocket damages. It's quite difficult. And so that's another area that's a weakness in the law that people are now considering whether injunctive relief might be something that we want to put into the law going forward. Okay. That's what we have. You're going to have access to this. There's some Privacy Act resources here. And I think if we have a little time left, we could take a few questions.
Thank you. I've been monitoring the chat. I'm going to try to get through some of these. The first one I'm going to ask you guys is, so the Privacy Act doesn't apply to state and local governments, but does it apply to data the federal government receives from state and local governments?
Yes.
That's a good question.
Depending on the conditions under which that data is collected from state and local governments. So if it's a required, so anything where it is coming under federal law, so any kind of voluntary data collection or required data collection, like your performance reporting, once it hits the federal filing cabinet, right, like our systems on the federal side, then it is covered by the Privacy Act. It is not covered by the Privacy Act when it is still on the state side of the fence. Also, once it comes in, if it's a completely voluntary transfer of data, for example, under a voluntary data sharing agreement, then both state privacy law and the Privacy Act would apply. But that's the only case in which those data, that information, would retain the state privacy law protections when that transfer happens.
Right. I would add one thing, which is when the data comes to the federal government, it still has to meet those requirements that Bethanne described for being in a system of records. It has to be retrieved records about individuals connected to their identifier and retrieved by that identifier. If you got a bunch of personal identifying information about people, but you only retrieve it by state, then it's not covered by the Privacy Act. I mean, unless there's some rules about whether there's an indexing system that allows you to find it, well, then it's, you can't just avoid the Privacy Act by moving it one step away with, where you actually have an index that you're using. If you're in practice really calling it up by somebody's identifier, then it's a system of records.
Okay, I have two related questions, okay? Or I think they're in the same neighborhood. Is information collected by a non-agency later shared with an agency a record, or must it be initially collected by an agency?
So yeah, so this is the same kind of concept, right? Like, we're just going to assume that it meets all of those other definitions, and all we're talking about is the agency piece. So as soon as it crosses that fence from non-agency to agency, then it becomes covered by the Privacy Act as soon as it hits the federal agency side. The inverse is also true. When the federal agency discloses data outside of that agency to someone who's not an agency, it loses Privacy
Yeah,
Act
that's
protection.
very important. I think what Bethanne just said is very important, that in many privacy laws, not all of them, but many privacy laws, including the Privacy Act, the protections of the law follow the custodian of the data. And so if you're holding the data, you're a covered agency under the Privacy Act, it's in a system of records, retrieved by identifier and so forth, all great. But once you disclose it to some other party that's not covered by the Privacy Act, the privacy protections no longer apply. So you can compare that to the situation of, for example, classified information. Classified information, the protections follow the data around. It continues to be declassified until the classifying agent, declassifies it.
There are some questions about if that information collection is being done by a company, but for the federal government.
Right. We briefly talked about this. If an agency hires a contractor to run a system of records, then yes, the contractor in that role is covered in the same way that the agency would be covered. And in fact, the employees of that entity are covered even by the criminal penalties in the same way that an agency official would be.
Right.
Okay. Now I have two questions. Oh, go ahead.
Sorry, I was just going to say, and in a lot of cases, right, like you're thinking about that in terms of like survey collection, like you're contracted out to do the survey collection, and it's going into a federal system of record. So that's where, like, not only do the clauses flow through, but it's also de facto, it has crossed that fence over into federal agency.
Great. These next couple are about matching. Can you discuss whether a propensity match score, such as one you would generate from merging a file with no identifier, but with demographic or location information to a marketing database that does have name and address in it, does that qualify as an identifier, and to what extent?
Go ahead.
I have thoughts. Okay. So the key piece here is that the identifier needs to be a direct identifier that's direct to the actual individual and record. And so depending on how you're setting up that match and what it looks like, right? Like if you're matching externally to a bunch of different things, it doesn't necessarily mean that you're bringing back all of the personal ID, but you might be generating a unique ID from all of that information that is coming back, which would allow you to tie that person and identify them individually. Mm-hmm. And if that's the case, where you can identify them and trace them back, then it would count. If not, then it wouldn't. And you can do it both ways, right? Like there are multiple ways to construct that. So it would depend.
Right, but a score that says 80% of the, 80% confidence that this person is on my list, that's not a direct identifier. That does not count.
Right. I was talking about like if you're
doing no, I agree. Yeah.
Okay. The next question is, if you access a restricted access file of individual observations using information about an individual to a match against observations and retrieve a single individual, could it somehow avoid both the definition of a record and a system of records and then be outside of the Privacy Act protections?
I
Agencies
think
try to do this.
Yeah. What?
Agencies do try to do this. They try to link things up without causing a system of records to come into being.
Right.
and use whatever linking information they have and then throw out the index, for example. In recent years, OMB, which is the agency responsible for oversight of the Privacy Act, has said that even if that index only exists for momentarily, that you need to publish it, and you need to identify that that's a system of records even for that small amount of time.
Mm-hmm.
And in fact, the Privacy Act, you didn't hear us mention it has to exist for a certain amount of time. It does not. And so some people think that OMB is being overly prescriptive about this. It's not very practical. Other people think that it's important to give notice and give the other protections when joining data sets together like that. Your mileage may vary.
Are agencies consistently doing that? Has this been tested in court? Those are different questions.
Right, exactly. Yeah.
Yeah. Another question, is the accounting of disclosures being maintained in the cases of DOJ reaching in to get information from agencies?
An excellent question. I think the answer is we do not know. But I doubt it. This is my own personal opinion. I'm not speaking for APDU or anyone else here, but I doubt that's happening. In fact, there are Freedom of Information Act requests for just that kind of information. Show me where you've disclosed all my data. And in many cases, those requests have not been answered. It's also the case that we're hearing, many of my colleagues, Freedom of Information officers, privacy officers are no longer with agencies. There's a severe shortage of officials who can process those requests. So, yeah.
Yeah, and this is tertiarily related to some of the whistleblower complaints, theoretically related to some of the disclosures that have come through in lawsuits.
Exactly.
Yeah.
Okay. Is there anything that you'd like participants to know that we haven't asked about? Is there anything that gives you hope with all of this?
Well, before we talk about hope, I also want to say one of the things we did not cover are the difference between Privacy Act exceptions, which are exceptions to the written consent rule. We did not have time to talk about the exemptions, which are cases where an agency can take away your Privacy Act rights, like kind of unilaterally. And there are also law enforcement exemptions. So you've got law enforcement exceptions, law enforcement exemptions, and also frequently law enforcement related routine uses. So that's a whole big world that's out there to be aware of.
Cool. Yeah, it's true. We didn't talk too much about that.
Well, you'll have to come back and join us and go through those, please.
Yeah, exemptions are complicated because there are places where an agency can take away your rights, essentially, for other good values that we think are important. The conduct of law enforcement has to continue, and we don't want people's background investigations out there or witnesses being identified, that sort of thing. And it covers that kind of thing.
Great.
And
well,
moving on to hope, just hope. I'm incredibly made hopeful by the amount of interest and engagement that folks have been showing in the Privacy Act and the broader privacy protections for our data. Like, that's actually really good.
That's great. Good.
I'm going to just put up our emails one more time.
Thank you.
So that you have them. Tell me if you can see my
Yeah, we're going to
screen.
be putting up a lot of links in the chat here, because as I thank Maya and Bethanne for being with us today, I know I speak for the entire APDU community when I relate how much we appreciate your time and your expertise. Anybody that wants to go back and watch this one or the previous one, these recordings will be on APDU's YouTube channel, and you should register for the next training, which is going to be about routine uses. And if you'd like to see more content like this, please let us know. Reach out to us at info@apdu.org. and let us know what else you'd like to hear. And you can check out our newsletter to find out about these upcoming presentations. And I want to thank everybody for joining us today. This was great.
Yeah.
Thank you. It was a pleasure.